Welcome to Dorsey and Whitney's Bank Counsel Roundtable, Banks at the Supreme Court. I'd like to introduce Nick Velitzstra, a partner and co-chair in Dorsey's Financial Services Regulatory Group. Take it away, Nick.
Thank you. Good afternoon, everyone. This is Nick Velitzstra. Welcome to our October session of Dorsey's Bank Counsel Roundtable. Thank you very much for joining us today. I'd like to start by mentioning a few housekeeping items. First, please remember to sign in on the attendance sheet we've provided and return it to attendance@dorsey.com. If you are looking for your attendance sheet or for today's presentation materials, they're available for download from the Dorsey webinar reminder email sent to you on Friday from events@dorsey.com. Finally, I wanted to mention we're not planning a formal Q&A session at the end of the panel presentation, but if you have questions for our speakers, you may submit them via the chat function, and our speakers will try to respond to those questions during the presentation if time allows, or they will respond to them afterward. Alternatively, you may contact any one of our speakers later using the contact information provided at the end of the presentation materials, or you can get in touch with your usual Dorsey relationship contact. Okay, next slide, please. All right, we've planned a 60-minute presentation, which we have entitled Banks at the Supreme Court on the docket and on the horizon. And we have three speakers on our panel, Tim Droske, Margeaux Serrano, and Eric Sherman. By way of introduction, Tim Droske co-chairs Dorsey's appellate practice group and has litigated appeals around the country, including for banking clients. His appellate experience extends to the U.S. Supreme Court, where Tim has written briefs successfully petitioning the court for review and resulting in unanimous victories from the court. Tim also teaches appellate advocacy at the University of Minnesota Law School as an adjunct professor. Tim's based in the firm's Minneapolis office. Margeaux Serrano is an associate in Dorsey's trial group. Her litigation experience includes complex federal litigation, commercial litigation, financial services litigation, and securities litigation, and Margeaux is based in our Seattle office. Finally, Eric Sherman is a partner in the firm's Securities and Financial Services Litigation Practice Group. Eric has more than a decade's experience representing banks, corporate trustees, and other financial services firms in a variety of complex and class action litigation in courts throughout the country. More detailed bios of our speakers are in your materials, as is their contact information. And with that, I'll hand it over to my colleague, Tim Droske. Thanks, Tim.
Well, thank you, Nick, and thank you, everyone, for participating in this CLE today. The general overview for what we're going to discuss over the next hour is we'll first talk a little bit about the Supreme Court last term, where it is right now, revisit a couple of cases from the last term that pertain to banking, the banking industry. And then the bulk of our time is going to focus on where the court is going from here. We'll discuss some cases that are on the court's docket and are going to be decided this upcoming term. And we'll also look at some petitions for review for certiorari that are currently pending before the court, and based on current indications, seem to have gotten some traction at the Supreme Court, where review is likely to be granted in the future, either on this case or potentially on those issues down the road. So let's first talk about the current state of the U.S. Supreme Court. The Supreme Court as an institution generally tries to keep a relatively low profile in the public compared to the other branches of the federal government, but it's been anything but that over the past couple of months in particular, largely due to the sad and surprising passing of Justice Ginsburg in late September. The Supreme Court started its October 2020 term in the first week of October, like it does every year, and has started that term with only 8 members on the court. Now, while the court has tried to proceed like it's business as usual, that to some degree is just not the reality. The court has already heard arguments in about 10 cases or so over the early weeks of October, and those cases are going to be decided by the same 8 members of the court who sat for oral argument. So while Judge Amy Barrett from the Seventh Circuit has been nominated by President Trump and is actually expected later this evening to be confirmed by the Senate and become Justice Amy Barrett as early as tomorrow if she's sworn in by the Chief Justice, for the 10 cases or so that have already been argued, she will not sit and help decide those cases. That raises the possibility of a 4-4 split on those decisions if the court can't come to a majority decision. And if that were to happen on any of those cases, the court will issue simply a one-line summary order saying that by reason of an equally divided court, the lower court's opinion is summarily affirmed. It's a non-precedential decision, and frankly, it's a pretty unfulfilling result for the number of hours and the length of time and the amount of money that's poured into this kind of litigation, and unsatisfying for the American public as well, that the Supreme Court, who only decides about 70 or 75 cases a term on average, would have a number of cases that would result in that kind of 4-4 split. So we'll see if that in fact happens with any of the 10 cases, but the main point is that regardless of whether Judge Barrett becomes Justice Barrett as of tomorrow, there are going to be some cases that are going to be decided just by an 8-member court. All eyes have certainly been on Judge Amy Barrett over the past few weeks since her nomination. She has been a Seventh Circuit judge for the past 3 years and a longtime constitutional law scholar at the University of Notre Dame Law School before that. She was a former clerk of Justice Scalia and has touted him as her mentor and role model. So the question then for courts, for all sorts of cases, but then in particular for the banking industry, is what kind of impact will having Judge Barrett on the court have for the court? It's a little bit unclear. The practical reality is that very few cases before the Supreme Court are decided on a 5-4 split. This past term, it was only 23% of the court's cases that were decided on that kind of voting alignment. The majority are decided, most cases are actually decided unanimously or, in a far less split manner. And many of those 5-4 cases are often dealing with hot button social issues or constitutional questions. You think of abortion cases or religious rights, things of that nature. That doesn't mean that 5-4 cases can't involve the financial industry or general civil litigation. U.S. Bank was actually before the court last term in a case and won on a 5-4 split along traditional conservative and liberal lines. In terms of how Judge Barrett's place on the court will change compared to when Justice Ginsburg was on the court, will partially depend on looking at cases where there was something other than the traditional 5-4 split on the court. Again, there's already been a conservative majority on the court, and so Justice Ginsburg's replacement by Judge Barrett isn't going to swing the court in a new way unless there was some sort of different kind of voting alignment in cases. And so that really requires looking at Chief Justice Roberts and where are cases where he, as kind of the new pivotal swing vote, has been willing to depart from his conservative colleagues and instead join the liberal members of the court. I think one area where this could be significant to the banking industry is with respect to agency cases, administrative action. Certainly banks live in that regulatory state with heavy agency regulation, supervision, and things like that. And there have been a number of challenges to the Trump administration's administrative actions and whether they're arbitrary and capricious. And in some significant rulings from the last term involving, for example, the census questionnaire or the immigration DACA program, Chief Justice Roberts joined with the 4 more liberal members of the court to find that the agency action there was arbitrary and capricious. Now, again, there's a question of whether that something similarly contentious could arise in the banking area, but that at least would be a possibility where Judge Barrett's confirmation on the court could have an impact. Another thing that continues to impact the court is COVID-19. The Supreme Court is historically a reactionary body. It waits to see what the lower courts do before it takes any action. But with respect to COVID, it has really been on the front lines. It was one of the first courts to modify its procedures in light of the COVID-19 pandemic. And it's done so in a couple of ways that can impact litigants, including banks who are practicing in litigation. The first is that it extended the time frame for petitioning the court for writ of certiorari from the usual 90 days out to 150 days, so close to half a year. What that means is that if you receive any sort of adverse decision from the Court of Appeals, it gives you that much more time to consider whether you want to petition the Supreme Court. If so, who you want to have represent you, whether you stay with trial counsel or bring in new attorneys, and to put that petition together, try to solicit amici to come on board. There's just more time for that whole process right now. Conversely, if you're successful at the Court of Appeals, it's going to take you that much longer before you can finally say that case is complete. Again, even after you win before the Court of Appeals, you'd have to wait 150 days, almost a half a year, before you can say that litigation is completely finished. COVID-19 has also impacted just simply how the court does oral arguments, as opposed to it live and in person with rapid fire questioning from the justices. It's all being done telephonically right now. Each justice is given a certain allocated number of minutes to ask their questions, and that has resulted in a different dynamic at the court. For example, Justice Thomas has been historically silent over his tenure on the bench, but now with these kind of fixed allocated minutes to him, and him by seniority being one of the first people given an opportunity to ask questions, he's taking advantage of that regularly. And so we'll continue to see as the term moves forward, how the Supreme Court manages its business, but that is kind of the general overview of where the court is right now. So before we preview what's coming up for the court in the future, we want to do some follow-up from last term. There were two cases that we discussed in prior banking roundtable events talking about the Supreme Court that were decided by the term last year. One was the case Rotkisk versus Clem. And this was a Fair Debt Collection Practices Act case dealing with the statute of limitations. The statute says that an action to enforce any liability created by the subchapter must be brought in a U.S. District Court within 1 year from when the event occurred. And the question before the court was whether this is an occurrence rule or a discovery rule. Is it from within 1 year from when the occurrence occurred or 1 year from when the violation is discovered? Showing that these kind of procedurally discrete questions involving the financial industry often aren't that controversial, all 9 justices agreed that the occurrence rule should be the doctrine that applies here. The only place where there was a narrow limited dissent actually came from Justice Ginsburg, who would have remanded the case to determine whether the application of an equitable doctrine that would have effectively not had the statute of limitations begin to run based on an allegation of fraud, would have remanded for that to be considered, where the rest of the court deemed that waived. The other case that was decided last term that we've talked about previously is Ritson Group, Inc. v. Jackson Masonry, LLC. This is a bankruptcy-related case, again, so kind of a discrete area of law, dealing again with discrete kind of procedural issues. This case dealt with the question of when you could appeal. The holding here was that a bankruptcy court's order unreservedly denying relief from an automatic stay constitutes a final, immediately appealable order. The question there was whether denying relief from an automatic stay is what should trigger your right to appeal, or whether you should instead have to wait until the bankruptcy court's entire proceedings should wrap up, and something that would be more analogous to the final judgment rule in general civil litigation. The Supreme Court, in the unanimous opinion, again authored by Justice Ginsburg here, said that bankruptcy court is different. You have a lot of kind of discrete actions that are all brought within this bankruptcy umbrella, and therefore it made sense for there to be final appealable orders along the way rather than needing to wait for the whole bankruptcy proceeding to wrap up. The practical takeaway for litigators here is that it's important and always better to appeal early and be told by the Court of Appeals you appealed too soon and should bring your appeal later on, than to find yourself in the converse situation of not appealing right away, thinking that your right to an appeal isn't triggered until later on, and then being found to be without any sort of appellate relief. That's what happened to the litigant here. They thought that the denial from relief of the automatic stay was not something that was appealable, waited until the end, and then the district court, Court of Appeals, and then the Supreme Court all ultimately found, no, you had to bring your appeal earlier on, and now you're time barred from bringing it at this point. So that's just a litigation pointer. And with that, I think we're now going to turn to cases that are currently on the court's docket. Eric?
Thanks, Tim. Well, good afternoon, everybody, and thanks for joining us. Next on our Supreme Court menu, we have some alphabet soup. We're going to talk about a case that concerns the FHFA, the FNMA, and the FHLMC, the last two of which are probably better known to you as Fannie Mae and Freddie Mac. Now, these cases, Collins versus Mnuchin and Mnuchin versus Collins, both come really from the same case out of the Fifth Circuit. And the case had a bit of a tortured history there. The case was first heard by a three-judge panel, which split three ways. That decision was vacated when the case went en banc, and the en banc court produced 6 separate opinions, 2 of which drew different majorities. Neither the plaintiffs nor the defendants were very happy with that result, so both sides petitioned for cert, and both petitions were granted, yielding 4 issues for the court to decide that we'll dig into in more detail as we go along. Now, those of you who work with residential mortgages or residential mortgage-backed securities are likely already very familiar with the FHFA. Those who followed the 2008 financial crisis probably know a bit about it as well. But for those who don't know or may have forgotten, Congress created FHFA as an independent agency in the Housing and Economic Recovery Act of 2008 in the midst of the financial crisis. Congress gave it statutory powers to act as conservator of Fannie and Freddie, which powers it quickly exercised. Fannie and Freddie are, of course, government-sponsored entities that purchase, securitize, and guarantee home loans. That was 2008. Today it's 2020, and more than 12 years later, Fannie and Freddie are still in that conservatorship, and they are still controlled by FHFA. And though they are government-sponsored entities, Fannie and Freddie have shareholders, just like any other corporation. Many of those shareholders aren't all that excited that FHFA's conservatorship continues. It was supposed to be a temporary situation to make it through the crisis, but here we are and it's still in place. And a lot of that unhappiness has to do with the fact that while Fannie and Freddie have been the beneficiary of more than $190 billion worth of outlays from Treasury, they've sent back more than $300 billion. And the basic structure that's brought us to this point is this. When the conservatorship was established, Treasury pledged to provide Fannie and Freddie with the capital they needed in return for senior preferred stock. Initially, that preferred stock paid Treasury a 10% dividend. That changed in 2012 in something known as the Third Amendment. Now, we're not talking, of course, about the Third Amendment that prevents soldiers from moving into your spare bedroom. This is the Third Amendment to the preferred stock purchase agreements between Fannie and Freddie on the one hand and Treasury on the other. In the Third Amendment, the 10% dividend was eliminated and replaced by a structure in which Fannie and Freddie turn over basically all of their net earnings to Treasury, something known as the net worth sweep. And this net worth sweep sets the stage for our discussion of Collins versus Mnuchin. Collins versus Mnuchin is a shareholder challenge to that net worth sweep. And there were 2 broad grounds really for the shareholders' challenge. First, that Treasury and the FHFA exceeded their statutory powers by agreeing to the net worth sweep. And 2, that the FHFA is unconstitutionally structured. Now let's talk about the statutory claims. At least we'll talk about the one statutory claim that found traction in the court below. In a 9-7 en banc decision, the Fifth Circuit held that the net worth sweep exceeded FHFA's statutory powers as a conservator. And the argument that won is a fairly easy one to follow. The Fifth Circuit held that it was at least plausible, because this was presented on a motion to dismiss, It was at least plausible in an Iqbal Twombly sort of way for the shareholders to allege that handing over the entirety of Fannie and Freddie's net worth is inconsistent with the purposes of the conservatorship, which it held were to restore Fannie and Freddie's solvency and to conserve their assets. Giving away assets is not conserving assets, and you, FHFA, are a conservator, so said the Fifth Circuit. The government has two defenses to this, both of which the Fifth Circuit rejected. First, the government points to an anti-injunction clause in the Recovery Act. That clause prevents a court from taking any action that would restrain or affect the exercise of powers or functions of the agency, that is the FHFA, as a conservator. The Fifth Circuit looked at that clause and it says, well, you know, FHFA, when you're giving away the entire net worth of your wards, Fannie and Freddie, that is not one of your powers as conservator. So the anti-injunction clause, which only extends as far as the FHA's legitimate powers as a conservator, doesn't apply, said the Fifth Circuit. Second, the government points to a succession clause in the Recovery Act. And the succession clause provides that FHFA as conservator succeeds to certain shareholder rights, including the right to bring shareholder derivative actions. The Fifth Circuit concluded that the shareholders' claims are direct, not derivative. And so it determined that this succession clause was of no help to FHFA. Now on to the constitutional claim. The constitutional claim that the shareholders brought is essentially a separation of powers claim. The FHFA is an independent agency that exercises executive authority. The president appoints the director of the FHFA with the advice and consent of the Senate, but under the statute can only remove the director for cause. And the court that held that for cause restriction violated the president's removal power under Article 2 and the separation of powers doctrine. And unlike the statutory claim, which was presented in the context of a motion to dismiss, the constitutional claim was presented on cross motions for summary judgment. So by agreeing with the shareholders, the Fifth Circuit basically handed the shareholders a win on the constitutional claim. That in turn led the court to examine what the remedies should be for this constitutional violation. And again, a 9-7 en banc majority, a different one that had delivered the judgment on the merits, determined that the proper remedy was to sever the portion of the Removal Act that makes the director removable only for cause. The court refused to undo the net worth sweep for a couple of reasons. First, the sweep was only a single part of the Third Amendment and the overall funding arrangement between Treasury and the FHFA. It wouldn't be fair, essentially the Fifth Circuit decided, to allow the shareholders to get rid of the net worth sweep while they still get the benefit of a multi-billion-dollar line of credit from Treasury. If they, like the contract, they have to take the whole contract. And the other reason is that, the Third Amendment was a bilateral agreement, and even if the FHFA director was unconstitutionally appointed, his counterparty was the Treasury Secretary. And the Treasury Secretary doesn't suffer under the same constitutional infirmity as the FHFA director. He indisputably serves at the pleasure of the president. So the Fifth Circuit reasoned Article 2 doesn't require the court to undo the Third Amendment because if the president, exercising his Article 2 powers, had wanted to stop it, he could have. He could have simply told his Treasury Secretary not to agree to it. So the Fifth Circuit hands down its 6 opinions, and of course, neither side likes the result. The government doesn't like that the Fifth Circuit didn't give effect to the anti-injunction provision in the Recovery Act. It doesn't want courts interfering with what the FHFA is doing as conservator. It doesn't like that the Fifth Circuit held that the shareholders' claims were direct instead of derivative. On the other hand, the shareholders really hate the remedy they've gotten. They think it's no remedy at all because the net worth sweep is still there. So both sides petition for cert and both petitions are granted. Merits briefing in the case is ongoing. Argument is set for December 9th. Probably at some point next year, we'll find out if the High Court can find a consensus on the issues that yields fewer than the 6 opinions that the en banc Fifth Circuit turned out. The result, is bound to be interesting, I think, if Judge Barrett is confirmed, as it appears that she will be as soon as this evening. The FHFA structure is very similar to the CFPB structure. And the Dodd-Frank Act contains a similar removal restriction, or contained rather, because you'll recall that just this last June, the court took up the constitutionality of the CFPB, and Chief Justice Roberts crossed over to join the court's 4 liberal justices, including the late Justice Ginsburg, to produce the result that the CFPB could continue to exist, but the for-cause limitation of the Dodd-Frank Act on removal of its director had to go. What will a newly constituted conservative majority do? I don't know. I guess we'll have to wait and see.
Thank you, Eric. Yes, so Facebook Incorporated versus Duguid. This case came out of the Northern District of California to the Ninth Circuit. Now it is going to be heard in front of the Supreme Court this December, oral argument scheduled for December 8th. And it's an interesting case that's really the culmination of years of disputes over the definition of an automatic telephone dialing system. As interesting as it sounds. But the automatic telephone dialing system is kind of the heart of the Telephone Consumer Protection Act, the TCPA, which was enacted in 1991. So it's just about 30 years old. And a little history of the TCPA kind of sets up this conversation. It was enacted to really combat these automatically dialed calls that were made from a machine, a piece of equipment that could go through numbers sequentially and just keep trying different combinations of numbers, and they would end up tying up whole regions of phone lines. And there was a particular concern about emergency lines being tied up, and there was some testimony in front of Congress about how these automatically dialed calls would tie up multiple rooms in a hospital and people couldn't get through. So that's kind of the background of where it comes from. And it's really it's a nonpartisan issue. People hate robocalls. They still hate them today. So it had a lot of support when it passed, and it really addressed the problem, and it was by all means successful. The problem is, it's been a while since it was enacted and technology has really advanced. So now the courts have dealt with, I'd say over the past 10 years, but really the last 5 years, trying to figure out what an automatic telephone dialing system means in the modern age. The TCPA applied to fax messages back around when it was enacted. So it was it's natural progression to apply it to text messages. So that was established, and so now we have a situation where, lots of companies are using text message notifications to quickly get important information to consumers. So getting back to the Facebook case, what we have in the Facebook case is Noah Duguid filed a lawsuit against Facebook because he alleged he received messages that his Facebook account had been accessed. So they were security alert text messages. He didn't have a Facebook account, so that was part of the problem. And that goes to another issue with the modern technology and cell phone usage. There's a lot of recycled numbers. The Telephone Consumer Protection Act has an exception that companies, of course, can contact individuals when they've received express consent for the individuals to be contacted at a specific phone number. But now, that was back when pretty much there were only residential lines and phone numbers didn't change nearly as much. So now we're in a situation where people recycle cell phone numbers all the time. So in this particular case, Mr. Duguid likely had a recycled number from a user who had at one point signed up for Facebook using the cell phone number. He received these messages. He filed a class action lawsuit against Facebook, and the TCPA has pretty harsh penalties: $500 per telephone call that violates the act, per negligent call, $1,500 per willful call, and it's a pretty low standard to meet willfulness. You just have to demonstrate that the person calling or the entity calling had knowledge that this person had not consented. So say you call one time, the first time it's negligent. Okay, the person answers the phone. Oh, this is, I'm not that, I'm not Joe Schmo, sorry. So any call after that, when the first call would be a willful violation, because there's some grounds to argue that the company or the person calling should have known that it wasn't the intended recipient. So it's a tough, lots of tough penalties under the statute, which makes it a very popular plaintiff's attorney action and a popular class action. So a lot of companies are looking at this case, the Facebook case in front of the Supreme Court, to get some clarity on this law that really has some harsh penalties. So Mr. Duguid alleged that Facebook had contacted him. Facebook filed a motion to dismiss in the Northern District of California, stating that, among other things, the general nature of the allegation, they don't stand up to the definition of automatic telephone dialing system, because Facebook had messaged Mr. Duguid's phone, but it was an individualized message prompted by this access to a Facebook account. So inherently, it just does not meet the definition of an automatic telephone dialing system, because these messages weren't produced using a random or sequential number generator. They were rather targeted messages. And at one point, they had received consent to contact this message. So Facebook kind of raised a couple issues in its motion to dismiss, which the court granted Facebook's motion, and Mr. Duguid appealed to the Ninth Circuit. At the Ninth Circuit, they argued about the definition of automatic telephone dialing system. And Facebook argued that based on, and Tim, you can go ahead and go to the next slide, which shows the statutory language at issue. Yep. So Facebook argued, and the whole case in front of the Supreme Court really is a statutory text kind of interpretation argument. Facebook argues that to store or produce telephone numbers using a random or sequential number generator and to dial such numbers, it reads that store and produce, or excuse me, using a random or sequential number generator applies to storing and producing. So you have to use a random or sequential number generator to bring the equipment within the scope of the TCPA. Whereas Mr. Duguid argues that it's fine for equipment to have the capacity to store phone numbers. And even if it's not using a random or sequential number generator, just the capacity to store and produce those numbers and then automatically dial those numbers would bring the equipment within the scope of the TCPA. And the Ninth Circuit, while acknowledging certain issues with Mr. Duguid's the broad definition argued by Mr. Duguid, it found that just based on a statutory reading that the TCPA would apply to any equipment that has that capacity. When on appeal to the Supreme Court, Facebook is arguing that that is a too broad of a definition of automatic telephone dialing system, and it's inconsistent with the purpose of the Act. Let's see. Mr. Duguid argues that applying a prohibition to, so getting back to the text message to a targeted number, as was the case in this Facebook case, Mr. Duguid argues that that's the whole purpose of the Telephone Consumer Protection Act, is to block these kind of annoying calls that are automatically generated. So if the Supreme Court agrees with Facebook's argument that its equipment does not fall into the definition of ATDS, kind of it makes the TCPA just lacks any kind of enforcement or teeth. And so, that's generally Mr. Duguid's argument is more of a policy position. And the argument that Facebook has, which is that, the scope of this statutory language to include the way that Mr. Duguid argues that the text should be read so broadly to include basically an iPhone, which everyone has today, Mr. Dewey's only kind of response to that is that, the Supreme Court shouldn't rob the statute of its teeth. But really, this has been going on for 5 years, starting with going back to the purpose of the TCPA and the issue with the statutory definition of an automatic telephone dialing system. Back in 2015, acknowledging the issues with this statute, the FCC, which has the authority to issue regulations related to the TCPA, they issued a definition, an automatic telephone dialing system that was very broad. And then there are challenges to that decision that the DC Circuit, in a ruling called the ACA ruling, the DC Circuit overruled the FCC's definition. And the Third Circuit has also weighed in on this issue and has kind of agreed with the DC Circuit and has not found such a broad reading of an ATDS to include any equipment that just has the capacity to store numbers, but rather the DC Circuit and the Third Circuit have agreed with the judge's decision out of the Northern District of California in this Facebook case that, that would be way too broad of a reading. Rather, the subpart B of the statute must also apply, and essentially a plaintiff must be able to demonstrate that the defendant they've sued not only used equipment with the capacity to store and produce numbers automatically, but must have used a random or sequential number generator to dial the numbers. So when the Ninth Circuit here kind of disagreed with the DC Circuit and the Third Circuit, causing a circuit split, which is ultimately probably why, this case has made it to the Supreme Court, and the Supreme Court granted the petition, Facebook's petition, to resolve this issue, because it's been a good 5 years of a lot of inconsistent rulings around the country, and now there's a circuit split, and a lot of different parties are weighing in. A lot of companies are filing amicus briefs talking about the issue. As I said in the outset, the TCPA has harsh penalties, and it's generally kind of an outdated statute. But so we'll see what the Supreme Court does with this definition.
Thanks, Margeaux. The last case that is currently on the court's docket that we're going to discuss is Ford Motor Company v. Bandemere and its consolidated case, Ford Motor Company v. Montana 8th Judicial District Court. Now, obviously, Ford Motor Company is not a bank, but the issue that's arising in this case is one that banking institutions, especially those that have a nationwide presence, certainly one beyond a single state, have to wrestle with all the time in litigation, and that's the question of personal jurisdiction. So this is a specific jurisdiction case, distinguished from a general jurisdiction case. A quick 30-second primer on the distinction between the two is that the due process clause has been interpreted as allowing a defendant to be sued in whatever state is kind of its home base. And so regardless of what the plaintiff's claims relate to, they can always sue where the defendant is, where the defendant's home is, where their headquarters is, for example. But outside of that, you have to deal with specific jurisdiction. And the principle here is what is fair to the defendant in terms of where they can be hailed into court. And so the International Shoe decision and a long line of personal jurisdictions cases establish that specific jurisdiction requires that the defendant have done something to purposely avail themselves of a particular jurisdiction. And then generally, there's been understood to be this requirement that the lawsuit in question relates to the defendant's conduct in that jurisdiction. And that's really the issue here. Ford is certainly a company that does business all around the country, right? I mean, they're advertising everywhere, selling cars everywhere. Here, cars that were bought used, so secondhand used Ford vehicles, were involved in car crashes in Minnesota and Montana for different products liability claims coming out of each case. Suit was brought where the accident occurred, and the argument is, Ford advertises here, Ford's selling cars here, including the model that's at issue in the suit. They can certainly be hailed into court here. Ford said, hold on. The specific car at issue here wasn't sold in Minnesota or wasn't sold in Montana. It was bought somewhere else, sold somewhere else. And therefore, with respect to specific jurisdiction for this case, we can't be hailed into court here. Minnesota, the state of Minnesota, so this went up to the Minnesota Supreme Court, also the Montana Supreme Court. They both said, Ford, you can be sued here. And now the Supreme Court is taking that issue up. You know, over the past number of terms, the Supreme Court had narrowed the scope of where jurisdiction can occur in a number of different cases. And so the general trajectory of the court has been, again, to narrow where a defendant can be sued. And Ford Motor Company, in fact, is relying on the Bristol-Myers Squibb case, which involved kind of a mass tort action from a few years ago, to say that there needs to be kind of this causation requirement as part of the jurisdictional analysis here. And so that's Ford's point, is that there needs to be some sort of proximate cause relationship here. Oral arguments occurred earlier this month. So this is one of those cases where you have an 8-member court deciding the case. And there were a lot of different hypotheticals asked. The court seemed to be concerned about how advertising, especially in this internet age, could impact this kind of analysis. And I think one question for how much this holding, when it's ultimately issued, can directly apply to the banking industry is how much the decision just kind of revolves around products liability area and torts as opposed to, let's say, contract related actions. But I don't think you need to think too hard to see how this could potentially play out in the banking industry. Let's say that there's someone who, with the same bank that has a national presence, has a first mortgage in, let's say, North Dakota, got a car loan in North Dakota for their vehicle, drives it only in North Dakota, but also has a second home using the same bank for their mortgage in, let's say, Arizona. And let's say an issue arose with the car loan, and they think that they might get a more favorable venue in Arizona, which would go to the 9th Circuit, than, let's say, the very conservative 8th Circuit. Can they bring a suit against the bank in Arizona for their car loan when that car has only been driven and all the financial statements are going to the North Dakota address? It's those kind of questions that I think this case may tease out in the future. And so again, by the end of June, we should have a decision here. And I think it's just helpful when you're thinking about litigation in cases to always remember that personal jurisdiction is one of those arrows in the quiver that you can use. It's an argument that if you don't raise it right away on the pleadings in a 12b2 motion, you lose it. So it's different than subject matter jurisdiction in that respect. But it is something to be thinking about when you're involved in complex litigation. Eric?
Thanks, Tim. We actually do have one more case to talk about that has been the subject of a grant, and this is Henry Schein, Inc. versus Archer and White Sales, Inc. And this case is going to take us into the realm of the Federal Arbitration Act, which may be of interest to many of you, especially those of you who work in consumer banking or for card issuers. Because really, since about the 2011 decision in Concepcion, and especially with some of its progeny, arbitration clauses in customer and cardholder agreements have been an important tool in neutralizing consumer class actions. Now, this case, which is actually back at the court for the second time, addresses the question of who, as between the court and the arbitrator, gets to decide whether a claim stays in court or is sent to arbitration, something we call arbitrability. Say that 3 times fast. And this case arises in the context of an agreement where you have 2 things. First, you have a clause that says, we agree to arbitrate under AAA rules, the American Arbitration Association. Those AAA rules say that the arbitrator decides questions of arbitrability. Second, in the middle of that arbitration clause, you have the word except and certain types of cases that the parties agree should stay in court. And here the carve-outs are for actions seeking injunctive relief and intellectual property disputes, 2 fairly common carve-outs in commercial arbitration agreements. Now, Archer and White Sales sues Henry Schein, and it brings antitrust claims, and it makes a prayer for injunctive relief. So Archer and White points at the prayer for injunctive relief and argues that the case falls squarely in the carve-out and that it doesn't have to arbitrate. The district court in Texas agrees, and this is back in 2016. So the case goes up to the Fifth Circuit for the first time in 2017, and it affirms. It looks at the arbitration clause carve out for action seeking injunctive relief. It looks at the complaint seeking injunctive relief, and it says, yep, defendant, your argument for arbitrability here is, well, it's really pretty bad. In fact, it is, quote, wholly groundless, end quote. And because it is wholly groundless, we don't even have to bother sending this case to an arbitrator to decide arbitrability. Even though the contract says, by electing AAA rules, questions of arbitrability are supposed to be decided by the arbitrator. Henry Schein doesn't like that result. It petitions for cert. Cert is granted. And the Supreme Court reverses the Fifth Circuit in 2019. It says, look, the FAA makes the question of who decides arbitrability a matter of contract. And when the contract says an arbitrator is to decide arbitrability, then the arbitrator has to decide that, no matter how bad or how groundless the argument may be. There's no wholly groundless exception anywhere in the FAA. But the court says to the Fifth Circuit, you really didn't decide what the contract says about who decides arbitrability. So take the case back, look at the contract, and figure out whether it contains, quote, clear and unmistakable evidence, end quote, that the arbitrator was to decide arbitrability. So the Fifth Circuit takes up the case for the second time. Archer and White argues that the carve out for injunctive relief means there's no agreement to arbitrate. And if there's no agreement to arbitrate, there's no agreement to apply AAA rules. And if there's no agreement to apply AAA rules, then you don't even get to the delegation rule that is embedded in those AAA rules. Henry Schein, on the other hand, argues that the carve-out does not trump the selection of AAA rules and the incorporation of its rule on delegation. The Fifth Circuit rules for Archer and White a second time. And it holds that you don't get to the point of looking at the AAA rules when you have a claim for injunctive relief because you haven't agreed to arbitrate that claim in accordance with the AAA rules. So there's no clear and unmistakable intent to delegate arbitrability, and the claims stay in court because injunctive relief is being requested. Henry Schein is once again unhappy. It again petitions for cert, and cert is granted once again. Briefing in this case is still underway. Argument has been set for December 8th. It'll be interesting to see how it turns out. On the one hand, it would seem impractical in the face of an unambiguous carve-out to send a case to arbitration just to decide arbitrability and assumably have the case sent right back to court. But who knows? I guess we'll all find out next year. Now we're going to turn to petitions to watch, petitions that haven't been granted yet, but in each of these cases, we know that at least one justice has called for a response to the petition. Not every petition gets a response, of course. So that's a sign that, these are issues that the court might look to address. The first is another Federal Arbitration Act case, Oman versus Milliman. The issues presented in that case come out of the insurance world, but at least one of the questions presented, the first one, has somewhat broader implications. Oman is an insurance company liquidator appointed under an Iowa statute. He's charged with winding up the affairs of a health insurance company that went under. In his capacity as liquidator, he sued out some tort claims in Iowa State Court against an actuarial firm that did some consulting work for the failed insurer. Relying on an arbitration clause in its consulting agreement, the actuary moved to compel arbitration. In response, the liquidator says, not so fast. I'm going to use my statutory authority as liquidator to disavow the consulting agreement. Because if I disavow the consulting agreement, the arbitration clause goes with it. And the FAA can't stand in my way because my statutory power to disavow the contract containing the arbitration clause doesn't discriminate against arbitration. All of the contract's provisions, arbitration clause included, stand on an equal footing in this scenario, and I'm going to disavow all of them. Now, this gets appealed up to the Iowa Supreme Court, and that court holds essentially that the liquidator is too clever by half. The court notes that the consulting contract had already been fully performed. leaving the arbitration clause as really the only unfulfilled promise left in the entire contract. And in that context, to allow the liquidator to disavow the contract is effectively allowing the liquidator to disavow the arbitration clause only, because it's the only part left. And under the FAA, state law cannot discriminate against arbitration agreements. And so the liquidator has to arbitrate. So says the Iowa Supreme Court. The cert petition, as we noted, went to conference, and it came out with a request for a response from the actuary. It only takes that one justice to call for that sort of response. So we don't just yet know how interested the court is in the case, but we think it's one to watch. Now Margeaux is going to talk about a couple of petitions in receivership cases.
Thanks, Eric. Yep, these are two linked receivership cases, Zacharias versus Janvey, and then Rupert versus Janvey. In these cases, both stem from the same litigation filed by the Securities and Exchange Commission in the Northern District of Texas against Robert Allen Stanford and the Stanford International Bank and other Stanford entities. And it was related to a massive Ponzi scheme that kind of came to a head during the 2008 financial crisis. In the Northern District of Texas appointed a receiver, Ralph Janvey, to oversee these entities and pursue claims on behalf of the defrauded investors. And then going about these efforts, entered into certain settlements that are now being challenged by defrauded investors. Challenged generally for they're arguing that, if the receivership estate didn't suffer the individualized injury, then they shouldn't be able to settle these claims. So these cases raise interesting standing issues, interesting Article 3 issues that have the potential to impact the authority a receiver has over winding up an estate in pursuing claims. And they'll generally be interesting for banks just because banks do engage receivers and are creditors sometimes. So it'll be interesting to watch and figure out what kind of authority the Supreme Court thinks these receivers have under Article 3. And with that, just given the time, I'm going to turn it to him to talk about an interesting petition to watch.
Thanks, Margeaux. The last case we're going to discuss is Deutsche Bank Trust Company Americas v. Robert R. McCormick Foundation. Now, this case has moved a little bit farther along in terms of the petition to watch process than the other two. This case has had a call for the views of the Solicitor General requested. What that means is that 4 members of the court have asked for the United States government to give its perspective on this case. And that's significant because you also need 4 votes to grant certiorari in a case. So you have 4 justices interested. So this probably tilts the case to at least the 50-50 pile in terms of its likelihood of certiorari being granted. Now, the U.S. hasn't weighed in yet, but we'll give a kind of an overview here of what the case is about. The case involves 11 U.S.C. 546E. And that's the safe harbor provision in the bankruptcy code, which exempts from a bankruptcy trustee's avoidance powers certain transfers by or to financial institutions. And this statutory provision comes up a lot in the context of leverage buyouts that then tilt into bankruptcy. And that's what you had happen here. So the factual context is that the Tribune Company, which had media holdings from the Chicago Tribune and others, was part of a leveraged buyout. And the shareholders who received the payout from that leveraged buyout included the respondents here, the Robert R. McCormick Foundation. And when the Tribune Company then tilted into bankruptcy, its creditors wanted to bring fraudulent transfer claims because they were left empty-handed. And that includes the petitioners here, Deutsche Bank Trust Company Americas. What these creditors decided to do was to bring state law fraudulent transfer claims here under New York law to try to claw back some of that money. There was a bankruptcy proceeding because the Tribune Company was in Chapter 11. And when that bankruptcy case reached the Second Circuit put the brakes on those state law fraudulent transfer actions. It said that those claims were preempted by 11 USC section 546E. And what's notable is it said that it was preempted even though there's no express preemption provision in 546E. Instead, it relied on implied preemption, that it would frustrate the obstacles and the purpose of 546E if these state law claims were allowed to continue. And what the petitioners are arguing here is that there are a few problems with that preemption analysis. First of all, to try to, I think, kind of create or show that there was some sort of circuit split, they've raised the issue of the presumption against preemption. Now, liberal members of the court often invoke the presumption against preemption. More traditionally conservative members of the court often show a certain disdain for the presumption against preemption. But the basic principle behind it is that when a state is exercising its historic police powers, there's a presumption against preemption applying in that case, unless Congress is really explicit about it. And a number of other circuits have indicated, at least according to the cert petition here, have indicated that there is a presumption against preemption that applies in the bankruptcy context. Second Circuit said, no, there's not. And so that was part of what precipitated their finding of preemption here. Even if you get past the presumption against preemption, you have the question of whether 546E really has this preemptive sweep here. Now, again, there's no express preemption provision. In 546E, the safe harbor there is really specific to what the bankruptcy trustee can or can't do. That's there based on the plain language of the statutory provision at issue. And so the petitioners are arguing, well, there's no reason that statutory provision specific to what the bankruptcy trustee can or can't do should preempt state law causes of action brought by creditors rather than the trustee. The other argument they make is that the purpose that the Second Circuit relied on in terms of what 546E is about was held not to be the case by the U.S. Supreme Court just a few years ago. So the same statutory provision went before the Supreme Court just a couple of years ago in the case Merit Management v. FTI Consulting. That's a case that we actually discussed at this banking roundtable a couple of years ago. And there the court said that the safe harbor isn't quite as broad as what was being argued. Again, the safe harbor applies when there is a transfer by or to a financial institution. And what Merit Management asked is when the financial institution is just a conduit between, let's say, company A and company B, or shareholder B and company A, does that count to trigger the safe harbor? And the court said no. And in the process of that, rejected the idea that there's just this purpose of finality behind 546E. Well, it's the same purpose of finality that the Second Circuit relied upon to say that these state causes of action should be preempted. So it seems like the Second Circuit's reasoning may be on shaky footing, or is certainly probably enough to get the Supreme Court's interest in granting cert here and not just the call for the views of the Solicitor General. The other interesting thing about this case that I'll just talk about quickly is, again, the Supreme Court in Merit Management held that when a financial institution is operating as an intermediary, that's not enough to trigger the safe harbor. Justice Breyer, when he was kind of doing one of his rambling trains of thought questions and hypotheticals, pointed out that the definition of financial institution in the bankruptcy code is broad enough that arguably any company that's using a financial institution as an intermediary, that the company itself under the definition of the statute could be considered a financial institution, essentially swallowing the whole rule that the Supreme Court was making. That's again triggered here by this case, whether the law can be read so far, because the court here, Second Circuit here, in saying that 546E applies at all, it was clear that the Tribune Company wasn't a financial institution, as a general matter, but looking at the definition said, well, since it used a financial institution to get its payment, it is a financial institution for purposes of merits management. So we'll see what happens with this case, but this is one that I would expect certiorari to be granted in. Nick, back to you.
Thanks, Tim. Tim, Eric, and Margeaux, thank you for that presentation, and thank you, audience, for your time and attention. A reminder, please sign the attendance sheet and return it to attendance@dorsey.com. Also remember, if you still have questions for our speakers, contact them using the contact information in your materials, or again, get in touch with your usual Dorsey relationship contact. Thanks again, and have a great rest of your day.